we come to this, America's First Legal, which this is a copy of the actual filing. I'm sure you guys have probably kind of pulled some high points from this. Obviously, we don't need to read everything. For those wondering, the actual website is here. America's First Legal files a federal rights complaint against the Walt Disney Company for illegal race and sex discrimination. And I'm just hoping and betting that eventually, some of these film threat articles from Alan Ng, the Disney files, maybe some of the stuff that we do might be attached as evidence. Who knows? Who knows? So let's talk about this complaint. Joe, Ron, tell us what we got going on here.
This is an EEOC complaint. Mm-hmm. This is not a lawsuit. Mm-hmm. One of the things you do in an employment discrimination situation, if you can, is get the government to do the investigating for you, because they have tools and they have authority that you as a private litigant may not be able to employ nearly as readily. And when especially you have a target such as Disney, which is very high profile and very large, you want as much help as you can possibly get. For one plaintiff's lawyer to go up against Disney, and again, it does require someone willing to step up and be that plaintiff, at least at the outset. It's much better if you can get the EEOC to do an investigation. For example, in this letter, what First America First
America First Legal, mm-hmm.
Right? What they've done is made a very powerful case, going back to our earlier discussion of what Disney explicitly admits it's doing, which is against the law. Mm-hmm. And they lay it out, and this is very powerful, because the next thing that happens is that Disney has 30 days from the filing of this letter to respond. Mm-hmm. After which the EEOC decides whether or not it's going to investigate. And then there's a 180-day period of investigation. There's not much investigation necessary when you're admitting that you have numerous policies that materially and substantially and systematically violate existing law. So at the very least, unlike in the case of, in a litigation matter, all Disney would have to do if they were sued using even the same exact facts laid out in the form of a complaint, Disney could just file an answer that says, we deny. And that would be the end of it for years to come. You wouldn't hear anything for a very, very long time. Then there would be a million fights over discovery. Here, Disney has to say within 30 days in the document that is inevitably going to become public, well, no, here's why we're allowed to do this. Here's our position on this. And at that point, it's possible that the EEOC will take action. It does have the ability to enforce employment discrimination. If it finds discrimination, it has the ability to mandate changes and to impose damages, but that doesn't rule out the ability of individuals to go ahead and file their own lawsuits. But meanwhile, you will have gotten the government to do an initial investigation, to have perhaps come up with certain findings with respect to the legality of their practices. If you then go into litigation with that as Exhibit A to your complaint, that's a very happy place to be for a plaintiff's employment lawyer.
Yeah, and I'll add on that. I mean, we're always talking about, will this survive? Will a complaint survive to beyond the motion to dismiss? And what Ron's point is that since this is not a complaint as far as the start of a lawsuit to recover damages, at this stage, whatever they're providing now becomes part of your ammunition to withstand any attack of trying to dismiss a potential complaint that would be filed down the road by an individual who is victimized by these policies. But if you look down at the remedies that they're seeking here, you go all the way down to the very bottom, the last few words, if you scroll down there, and look to like the remedies that they're asking for.
You talking about in the complaint or the website? I'm sorry.
And on this complaint that they filed, if you go down to the very last paragraph there, so what do they ask for? The two up higher.
Sorry. I thought you meant the last page.
No, that's right. Yeah, no, the written part there. Just go down there. They basically say that what they're looking for is a commissioner charge to be issued, which is basically, and that's not. Don't hit them with sanctions or penalties or anything of that nature. We want a commissioner charge, and the reason I suspect that they're looking to get that is they look at this as ammunition that will help them, or a potential client or individual who's victimized by these abusive and terribly illegal policies, to basically walk in there with a matter of liability virtually being established, at least on a broader level, and then you have to bring it back to how it applied and affected that particular plaintiff. But the broader liability that they feel like there's a good chance that you're pretty much walking into a lawsuit with ammunition that few plaintiffs ever walk into a litigation being armed with. This atom bomb there's even been a commissioner's charge that cites Disney for these willful violations of law and their practices. And here's our victim who's complaining now as the plaintiff in this individualized case that comes, let's say, a year from now, who's now citing that he was a victim of these policies, that the commissioner had to issue a charge because they were so terribly egregious. And I think that that's really what they're ultimately looking for. This is setting up plaintiffs to file lawsuits, assuming that especially if they succeed in getting that commissioner charge. And at the very very least, even if no commissioner's charge is issued, what you're always looking for as an attorney for litigants is you want to figure out exactly where your opposition is boxing themselves. A lot of the reasons that we'll have depositions and discovery is because there could be a 1,000 different answers as to why it is that the defendant you're complaining of took a particular action, and you want them to pick their poison, whatever that poison is. And it could be cyanide, it could be hemlock, but you need to know which poison they pick so you know where to attack them. And by them filing an official response to this EEOC complaint with respect to what their thinking was when they enacted these policies, they're in a very difficult time. If they realize that it's a poor strategy a year from now when they're facing a complaint, they're in a very difficult time also maneuvering to some brand new explanation as to why they did this. So it almost is serving as part of the discovery for broader litigations down the road that is being done on the government's dime, as Ron pointed out. So those are the different multiple layers as to how this can benefit attorneys for plaintiffs down the road.
Let me ask. Is it also fair to ask this? Is it fair to say that the EEOC tends to be a political entity, and that they do not have to give justification for not siding with you in their findings?
It has been notoriously political since the Bush years. But it has there is an appellate process from the EEOC. Like the commissioners can't really just plain shut it down. You can go from the EEOC to the courts, and they can, there's a lot available here that you can do. And the fact of the matter is, there's no real downside to sending this. If EEOC drops the ball, I mean, this is so open and notorious that it's going to be kind of hard for the EEOC to dodge this. On the other hand, we have seen a level of comfort with disregard for the rule of law in recent years, like let's say the last 3 years or so, that anything is possible. But there's no downside for America First on this, and it certainly doesn't help Disney management. I mean, going into the shareholders meeting. It's another thing for dissident shareholders to wave around.
Mm-hmm. And if what you're saying is true, and I'm sure it is, if Disney has 30 days, right, to respond to this, assuming that, I mean, Disney wouldn't just ignore it, or there would be serious consequences
right.
for not
That's out of the
responding.
question.
Okay.
Right.
So they would absolutely respond to this within 30 days. That means that legal response would be filed, and ostensibly, I would imagine, become public as soon as it's filed. I'm assuming it would be a public document, or do they hold that in confidence?
I believe it's a public document.
Okay,
yeah,
so
at the very least, the response would end up back in America First's hands, and they certainly are going to publish it.
right, Disney probably won't, but America's First, or First, I can't say that. I keep tongue twisting.
Right,
America's First Legal Foundation,
and there are so many of these. I mean, we have one too, the Dillon Law Group. The
right,
Center for American Liberty.
right.
We do similar kind of work. It is. Yes, that's an important point that I forgot after having raised it earlier on. That yes, Disney does have to respond,
and that response, if 30 days from now, even if they wait till the last minute to file,
which they will.
I would imagine they will. That would be, say, March 15th from the date, or March 16th, 30 days from whatever the date this was filed. That's still almost a solid month before the annual shareholder meeting. So all of that is going to be in the public ether well ahead of that meeting. Lots of fodder to discuss, which leads to my next question. Guys, play devil's advocate for a minute. So kind of brought up earlier the whole notion of this protected class stuff that has entered the public zeitgeist in our lexicon in the last 15, 20 years, where effectively it's okay to be racist as long as, it's not against this group or that group. Like, you got this kind of behavior, the hiring practices, it's all okay because we're helping underrepresented groups. There's this idea out there.
The protected class is language from the civil rights law. Mm. You have to, in order to qualify for discrimination, to make a discrimination claim, you have to be a member of a protected class. Mm-hmm. Protected class includes race, not a particular race. That's not what protected class means.
Right.
If you're discriminated against on the basis of race or on the basis of sex, you are a member of a protected class, and you can bring a claim. So it doesn't mean that the civil rights laws only apply for one kind of racism or one kind of sexism. Any kind of discrimination. The problem is, how do you square, how do we make the transition from a world in which affirmative action was legal to where it's illegal?
Right.
And the Harvard case went a long way towards spelling out to a lot of these judges who seem very confused about the idea about racism against white people, that there's no difference whether or not the victims are black or white. It's still racism, and that's what makes that decision one of the most critical decisions of and amongst a slew of critical decisions we've seen from this court over the last 3 or 4, 2-3 years, certainly. That as far as changing the tide and recognizing that there is no difference. It's all racism, no matter whether or not the left loves to claim there's no such thing as racism against white people. The Supreme Court has recognized that now, and that's highly significant.
And that was my point about saying the whole protected class idea is that's what the modern zeitgeist interprets it as, right? They take it as to meaning, oh no, this is specifically a certain type of race, a certain type of gender, a certain type. It basically, if you're white and male, you're not protected class. That's the idea now that has been twisted into. Mm-hmm. And that's why I think, this court case from last summer has such a big bearing on what America's First Legal here is doing. Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.